Welcome to Winning Isn't Easy. I'm Nancy Cavey. I'm a national ERISA and individual disability attorney. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say it, so I said it. Nothing, however, will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Life insurance claims are a whole other ballpark in the disability claims world. And today I'm going to walk you through some of these claim stories and discuss how it might be relevant to you. The topics are going to include, can you sue a fiduciary who fails to properly enroll your spouse in an ERISA life plan? In other words, it's not going to be you, by the way, it'll be your estate. Number two, is speeding a crime that can result in a life insurance claim being denied? And three, can a life insurance company deny payment of benefits based on alleged contaminated blood alcohol testing? This is really exciting stuff. I find it fascinating, but we're going to take a break before we get started and dive in. Welcome back to Winning Isn't Easy. Can a life insurance company deny payments of life insurance death benefits based on an alleged contaminated blood alcohol test? Now, the most common defense to a life insurance claim is the argument that the deceased was under the influence of drugs or alcohol at the time of the death in violation of the policy. This is called a drug or alcohol exclusion. And obviously, it requires blood work to prove the presence of and the level of drugs or alcohol in the decedent's bloodstream at the time of death. A common exclusion will say that a policy does not cover any loss caused in whole or part or resulting in whole or part from the insured person being under the influence of drugs or intoxicants unless taken under the advice of physician. Now, I'm asked, could there be an argument that the results of incorrect testing should be excluded as the basis of denial, and whether a life insurance carrier's destruction of samples should bar the carrier from raising the drug or alcohol exclusion? That's a lot of problematic issues, but they actually arose in the tragic story of Cody Waters. And Cody was killed in a single car rollover accident, and his parents sued AIG for Cody's life insurance benefits because he had been employed with Express Jest and had a policy. There was a witness who observed him weave in and out of traffic before he flipped the car, and Cody was ejected from the car and killed. His parents filed ultimately this life insurance death claim. But the autopsy that was performed by a doctor less than 12 hours after his death and of cardiac blood, vitreous fluid, and urine samples were tested. So there was an autopsy, there was blood, vitreous fluid, urine samples, all of which were drawn and tested. Now, only the cardiac blood and urine tests were sent for testing, and they revealed a blood alcohol of 0.113, which was more than Louisiana's 0.08 legal limit to operate a motor vehicle. The urine test was negative for drugs, and all of these test results were included in the autopsy report. The Shreveport Police Department traffic reconstruction and crash investigator closed the case, concluding that Cody's death was an accident with a causal factor of the crash determined to be the careless operation of a motor vehicle due to alcohol impairment. So the family files a claim with AIG. AIG says, well, wait a second, we're going to have these medical records reviewed by a toxicologist because we want to understand the level of impairment due to being under the influence of the intoxicants. AIG's toxicologist noted that there were some liability questions involving the testing because they had used the cardiac blood and not the vitreous fluid. AIG's toxicologist said that cardiac blood isn't ideal due to the fact that it's possible that if that there is still a large amount of alcohol in the stomach at the time of the death, and that can diffuse from the stomach to the heart, resulting in a false elevation of the blood alcohol. So the use of the cardiac blood raised an issue as to the accuracy of the blood alcohol results. Now, why that was an issue, I'm not quite sure, since it was still above the legal limit. But in any event, the AIG toxicologist concluded that the blood alcohol level was more than the legal blood alcohol limit, that he was impaired at the time of the accident, and that the intoxication and the impairment were the cause of the death. So AIG denies the claim. Now, from the very beginning, the Waters family and their attorney raised issues about the use of the cardiac blood, and they submit a report from a toxicologist that they hired. That toxicologist opined that the use of the cardiac blood to conclude that Cody was intoxicated at the time of the accident could be the result of postmortem fermentation and redistribution and diffusion. So obviously there's a huge dispute about the accuracy of the testing. Was there contamination? So did you use the right testing? Did you use the right sample? Is the sample accurate? Does it really show a level of legal intoxication? Well, AIG discovered that the vitreous samples still existed, and the samples were sent to an independent laboratory. The shipping instructions did not have any shipping instructions like, send this via cold shipping. And it didn't instruct the lab to store the samples or return the samples to LSU, AIG, or even the Waters. And what's worse is that the shipping paperwork authorized the lab to destroy the samples after 6 weeks. AIG ultimately cancels the testing because the samples weren't properly stored at LSU. AIG was notified prior to the destruction, but they didn't do anything to preserve the evidence. And of course, they never advised the family of any of this. Ultimately, the vitreous sample was destroyed. So AIG says, we've got a problem. So they have a second toxicologist review it, and that second toxicologist agrees that he was intoxicated based on the cardiac blood sample, and that because the vitreous blood sample hadn't been kept properly, that the results of that sample were invalid. So this ends up in court on the question of whether the expert toxicology report should be thrown out, what sanctions AIG should face for failing to preserve the evidence, whether Cody was intoxicated, whether the denial was proper. Obviously, a lot of issues riding on these blood tests. The ultimate issue, of course, is what's the level of alcohol that existed in Cody's system at the time of the accident, and did it contribute to the death? So this is a battle of toxicologists. Each side argues that the other side's experts aren't qualified and that the report was not scientifically sound under the Daubert standard of evidence. These are standard arguments that us lawyers make, but the judge quickly rejected those arguments, and they found that both toxicologists were qualified as experts to review a blood alcohol test, opine on the strengths and weakness of each test, respond to the testimony and positions of others. The court, by the way, found that the Daubert standard is inapplicable to a court's review of the administrative record in an ERISA case. And that's a topic for another day, but for us lawyers, it's a big deal. The court indicated, however, it would factor the parties' criticisms of each toxicologist in its analysis and weighing the weight that should be given to each toxicologist's opinions. Now, the court obviously has to address the destruction of the vitreous samples, and the court was not impressed with AIG's conduct. They found that AIG was a sophisticated party represented by counsel and thoroughly familiar with litigation and the need to preserve evidence. Noting that the destroyed evidence was crucial to both parties, the court decided that the appropriate remedy for AIG's conduct was a presumption that the vitreous sample would have revealed an alcohol content less than the results of the cardiac blood test. So now that the court has cleaned the deck, the court looks at the official investigation of the crash and what the third-party accident investigator concluded. Now, the investigator, as I said, had concluded that alcohol had contributed to the accident and to Cody's death. The judge accepted the opinion of the investigator and upheld the denial of benefits. So even after we go through all this rigmarole, if you will, and I don't mean to make light of it, but the judge ultimately says, I'm going to sort of decide this case based on what the investigator said, and probably, I'm sure, based on what that third-party witness had to say. You can see that even if there's a darn good argument for throwing out or constraining the use of a blood alcohol test, the denial of an insurance claim for death based on drug or alcohol exclusions can be tough. If you've had this situation, I'm so sorry for your loss. These cases can be tough, heartbreaking, not only for the family, but heartbreaking to be in court, to be fighting about life insurance benefits. I hope that you've learned a lot today in this episode. If you've enjoyed this episode, please consider liking this page, leaving a review, or sharing it with your friends and family. Please subscribe to this podcast. I think this podcast is a good vehicle to learn what you need to know about disability claims, life insurance claims, and I want you to be educated about the games that carriers play. I hope you tune in next week for another insightful episode of Winning Isn't Easy. Thanks.